Good morning, everyone. Happy St. Patrick's Day. My name is Cassie Hopkins, and I help coordinate the webinars and events for Hausman Johnson Insurance and the Benefit Services Group. I would like to welcome everyone to today's webinar, Top 5 Most Common Compliance Mistakes Made by Employers. A few housekeeping items. This webinar is interactive. It will feature a question and answer session at the end. You can type a question in during the webinar and Sarah will address it during the session. After the webinar is over, there will be a short survey we are hoping you can fill out for us to give us some feedback on the webinar and other webinar topics you are interested in learning more about. This webinar will also be recorded and will be available on the webinar archives section of our website. Each attendee will receive a follow-up email with a link to the recording and the presentation slides. I would now like to introduce you to our speaker, Sarah Borders. Sarah has spent the last 15 years in the employee benefits industry, has numerous designations, and serves on NAHU's Employer Working Group Subcommittee and is an active board member of Austin AHU. She recently stepped down as Vice President of Benefits Compliance at one of the nation's largest brokerage firms to start her own compliance consulting practice. Her designations include an active license with the Texas Department of Insurance, CEBS, Certified Healthcare Reform Professional, HIPAA certification, and Healthcare Service Associate. She holds an MBA from Texas A&M Corpus Christi and a BA from the University of Incarnate Word. Her consulting firm, Benefit Compliance Solutions, partners with employers to identify unknown risks and avoid hundreds of thousands of dollars in fines and lawsuits and failure to comply with health plan obligations. Welcome, Sarah.
Thank you so much, Cassie. Welcome, everybody. I'm so excited to be with you today and to go through the top 5 compliance mistakes that we see quite a few employers making and give you some steps and some tips to mitigate that risk and really to be able to further come into compliance with your health plan obligations. And so we are also going to touch on the latest COBRA legislation and outbreak period rules because those are very timely and very important for you to understand. BSG and Hausman Johnson has many resources and we are working on that daily. So please reach out to your account manager, your representative for more assistance with that. Also watch for emails and other resources coming through the next few days and weeks. So today we are going to touch on first why you should even care about compliance in the first place. It isn't very exciting. It is one of those things that is oftentimes overlooked. You have many things on your plate every day, and complying with your health plan obligations often falls to the wayside until there's a lawsuit or until there's an IRS penalty letter that shows up or some other sort of complaint from an employee. So we want to make sure that you know what you're supposed to be doing. And so today I'm going to talk about the top 5 compliance mistakes and steps on how to fix them. We'll talk first about HIPAA, privacy and security. Then we'll talk about the plan document and SPD requirement. We'll talk about your handbook and how it relates to the materials in both your summary plan description and your other employee benefit notifications. Then we'll talk about some confusion on who is actually eligible for benefits under the Affordable Care Act's definition of a full-time employee. And then number 1, we'll talk about COBRA. This will also include, again, the ARPA sweeping legislation that was just passed last week, as well as these COBRA outbreak period timelines that essentially have been suspended and will restart depending on when the employee triggered COBRA. So we'll go into all of that today. So first of all, I'd like to take a pulse before we get started, take a little bit of a poll question here. How confident do you feel about meeting your company's health plan and employee benefit obligations? Is it A, we're pretty confident overall, we're on top of it. B, we've got some work to do and you already know that. C, you're feeling nervous and you need some help. Maybe you're kind of kept up at night reading all these regulations coming at you. D, you are totally lost and likely not compliant at all. Maybe you're new to your organization and the previous person didn't focus that much on compliance. Perhaps that's you. So we just want to know where you're at before we get started, and then we're going to take your pulse after we've talked about the 5 top mistakes. So go ahead and take that poll question. We'd love to see those results. Okay, so we see the results here. We've got about a good portion of people feeling pretty confident, so that's great to see. Next in line is we've got some work to do. So we're seeing about half and half. So let's see what how that changes, if it changes at all by the end of this presentation. Okay, so first of all, why would you even care about compliance at all? And there's a couple of different reasons, and some maybe you haven't thought of before. Of course, the first one is going to be so we can avoid getting in trouble, avoid fines and penalties and lawsuits. You avoid time correcting those errors. But remember that compliance, being in compliance and staying within the guidelines also protects your business. It also protects the benefits that you offer and gives some rails between what the employee is promised and what you are offering as the employer. It also protects the employees, and this is key because you have a fiduciary duty under ERISA to actually protect the employees. This actually is employee specific rather than employer specific, and we're going to talk about the plan fiduciary requirements in just a moment. Also, it gives a helpful framework to avoid abuse. So oftentimes we look at compliance as being very burdensome for the employer. Why do we have to do these things? This is so stringent on us. But actually, it helps to know if you're in compliance, if you have your plan documents in place, if you have policies and procedures in place, then you can look back at your documents and know right away on how something is supposed to go. So in other words, if there's a claim dispute, or if there's a question about whether somebody's eligible for coverage or COBRA, you have these policies already written. You can defer to them, you can look at them, they're in writing, they've been disclosed, and it kind of stops right there. Any further action can be nipped in the bud right there, and then you can move on to the next thing that's in line, the other things that are on your plate. So it is a very helpful framework to know what you have to do and what the employees have to do. So moving on to this idea of a plan fiduciary. A fiduciary is really any person or entity who makes decisions regarding the management of the plan or plan assets. It's not a function of somebody who's just purely an administrative person. It's more about who makes those decisions regarding the management of the plan, meaning the health plan. Health plan here, you're going to hear me say that word a lot. I'm talking about not only the major medical, but also the dental, vision, FSA, disability, group term life insurance, all of those benefits that you offer to your employees that are non-retirement. And also the plan assets, meaning the money that's exchanged, the money that you take from employees' paychecks to withhold to be able to pay claims or pay providers or pay insurance carriers. So those types of functions really are going to make somebody a fiduciary, which is a heightened level of responsibility. So ERISA fiduciaries, and ERISA is this law that was passed back in the 70s, really, that relates to making sure that both retirement plans and health and welfare benefits, meaning the group health plan, dental, vision, all of that, is acting in the best interest of the participants and the beneficiaries' interests. So it's this duty of loyalty, meaning this law is very interested in protecting the rights and the promised benefits for the participants and beneficiaries, meaning the employees and the dependents that are enrolled in your benefits. This law wants to make sure that you are looking at them and making sure that the benefits promised and provided to them are what they say they are. Also, there's a duty to use any plan assets to pay benefits or reasonable plan administration expenses, this exclusive benefit rule. So it has to be, the money that is spent has to be in the best interest of the participants and beneficiaries. You have to act with the same skill, prudence, and diligence of a prudent person acting in a similar situation who is also familiar with such matters. So in other words, you have to act in a manner that is reasonable for a prudent person, somebody who at this level would understand this is sort of kind of like a common sense test, in other words. Minimizing risks of large losses by diversifying plan investments. This has to do more with the retirement plan side of things, but it's always important that you're monitoring your service providers, you're monitoring the cost, you're monitoring how much they're charging to you, because we want to always make sure that it doesn't necessarily benefit the employer, but the employees, the participants on the plan. Also, you have to follow the plan documents and the plan terms. And I'm going to talk more about the last one today, the plan document rule. And that is where the protection of the employees comes into place, yes, but also the business and the employer, because you have it all laid out in a written plan document. If there was ever a dispute, that would actually look straight at the plan document and it would be there in black and white. So it's really important that we get these plan documents in place and that they're correct. If a breach of any of these duties causes harm or loss to the plan participant, civil penalties can apply, including being held personally liable. And we do see case law with that happening when someone has acted or breached their fiduciary duties and there's some kind of gross negligence. You see that. So it's very important that you understand that you may be a plan fiduciary and that you have these heightened requirements under this law, ERISA. Okay, so kind of having that as a framework, so to speak, let's look at the top 5 compliance mistakes and what they are and how to fix them if you're not currently complying with them. So first of all, we're going to look at HIPAA, the plan document, the handbook, ACA full-time employees misclassified, and COBRA. So number 5, HIPAA, privacy and security. This is one that I see frequently. There is no compliance at all with this, and that's for good reason, because really when we think about HIPAA, we think about doctors' offices, hospitals. We don't have any health information, but in fact a group health plan has a lot of protected health information. So under the law, a group health plan is actually considered a covered entity under HIPAA, privacy and security. And that is because that group health plan is creating and maintaining and sending and storing what we call protected health information, meaning it's an identifiable with a person's name or some other identifier, such as a birth date, social security number, participant number, contract number, and a diagnosis. So for example, an EOB is very well protected health information. So if that plan is creating and maintaining and storing PHI, protected health information, then you have certain requirements under HIPAA that must be adhered to. So fully insured plans. So in other words, if you buy an insurance plan from a major medical carrier such as Blue Cross Blue Shield, Quartz, some other HMO provider, something like that, where you pay a premium for fully insured coverage, then there's this hands-off sort of status where you're not really seeing PHI other than maybe disenrollment, enrollment information. But if you have a self-insured plan, then that self-insured plan is a covered entity, and there is no way that you could be hands-off. Even if maybe you don't see the claims information, you still have access to it, and it's still being created by the health plan. So this can get pretty technical pretty quickly, but in general, I just want you to get the concept that a group health plan is considered a covered entity, and therefore when you are a covered entity, you have requirements under HIPAA. And that requirement is basically to apply administrative and technical safeguards to protect that PHI. So here's a list of what it means to kind of comply with HIPAA, in other words. First of all, we have to have required BAAs, business associate agreements, with all of the outside companies that are handling this protected health information. So that would be service providers, that would be administrators, that could be cloud providers, and even insurance brokers that are seeing this PHI. It's going back and forth between the covered entity and these other business associates. Also, a notice of privacy practices has to be distributed to plan participants. The plan has to be compliant with EDI and security requirements that govern electronic information. So this is where the IT people really come in. They have to understand, where is this PHI moving from? Are there safeguards in place within the system itself, the electronic system? Also, the plan has to be compliant with other laws regarding release of personal, financial, or medical records, or PHI. So there's other laws, there's state laws that apply to this type of sensitive information. There has to be a risk assessment training for the people that see PHI at least once per year. And there has to be appointed HIPAA, privacy, and security officers in place. Then, related to the risk assessment, policies and procedures have to be in place pertaining to what is found in the risk assessment and how your organization actually stores, maintains, protects this PHI, both physically and within a server or a cloud, or within your laptops and so forth. So this obviously sounds very complicated, and it is. There are a couple of very fantastic vendors that assist with HIPAA compliance for employer group health plans. And if you are feeling like you need some extra help, there are kind of do-it-yourself models. There is also levels where they can have somebody to help you. So if you're feeling like a little bit overwhelmed by this requirement, then please just let us know. We can get you some help. Okay, so sorry, there's a little bit of feedback here. Okay, so what to do if you're not currently compliant? And I think it's fair to say that most employer health plans are not currently complying with HIPAA, at least to this extent. Maybe some parts of it, maybe you encrypt some of your emails, maybe you do have a privacy officer in place or security officer in place, but really just take steps first to identify if you are hands-off or hands-on. And again, we can help you with that. Identify who has access to PHI, have those individuals take the HIPAA training. And this can be provided through, SHRM has HIPAA training. There are many different vendors that have excellent HIPAA training that can be given to these people who see PHI. Then conduct your risk assessment, implement policies and procedures, have those BAA, business associate agreements signed, and of course, try to use and consider using a HIPAA vendor for help with this, because there are many that do it in a very inexpensive cost. Okay, so the fourth biggest mistake that we see is the lack of a plan document, or SPD. And SPD stands for Summary Plan Description. So typically you will see that most self-insured plans have what is called an SPD. It's really the booklet from the self-insured TPA that explains the benefits of the medical plan and maybe even the prescription drug benefits. Sometimes they're together, sometimes the prescription drug benefit is separate from the medical plan. That is a SPD for the purposes of the major medical plan. Then you'll also see carrier certificates of coverage if you have a fully insured dental or vision plan that the insurance company has provided to you, that also list out the benefits that are provided under that insurance contract. This is not what we're talking about when we're talking about an ERISA plan document. It's sometimes called a WRAP plan, and many of you already have a WRAP document in place, or WRAP SPD in place. Instead, what this is, this plan document, this ERISA plan document, sometimes called a WRAP document, is this is a document that essentially has two functions. Number one, it wraps all of your group health plan benefits into one big ERISA plan. So in other words, it takes the medical, the prescription drug, the dental, the vision, the disability, the EAP. It wraps it all into one big ERISA plan, which is very helpful for filing your 5,500 for your health and welfare benefits. So if you didn't have this in place, then you may be filing one 5,500 for the medical, one for the dental, one for the disability. You may have separate ERISA plans. So this is nice because it allows you to make one big plan. Also, it requires specific language under ERISA. So this wrap document fills in the required ERISA language and disclosures in it, which is not contained in the summary plan description or carrier certificates of coverage. So really, if you don't have one of these wrap documents, or if you're not sure, I would look for it, see if you have one, and if you don't have one, reach out to us and we can get one of those in place for you ASAP. When you have one of these in place, this has to be provided to participants within 90 days of enrollment into the plan. So a lot of times we see when you do have one of these, it'll just be kind of contained in a library, maybe an online portal, but it isn't really disclosed to participants. Nobody is told that it's there. Nobody's told the importance of it or that they have a right to request a paper copy. So if you have one of these, but you're not distributing it currently, then you're going to need to do that. Also, again, you can't just leave it in a file. It has to be distributed, whether electronically or by paper, depending on if you're able or eligible to take advantage of the electronic disclosure rules for your employees. Also remember that there is a requirement for a cafeteria Section 125 plan, sometimes called a POP. This is a totally separate plan document that relates to whether or not you allow pre-tax benefits. So if you allow employees to pay for their benefits in a pre-tax basis, then you also have to have one of these cafeteria plans, sometimes called a POP, sometimes called Section 125 Premium Conversion Plan. It has a lot of names for the same thing. You also have to have one of those in place as well. So a common misconception is that, oh, we're too small to have a plan document. And that's actually not true. ERISA, if you are an ERISA plan, meaning you're not a church plan or a governmental plan, then ERISA applies to you, even if you have 5 employees. So the plan document requirement applies to you as well. Now, there is a small group exemption from filing the 5,500 if you have 100 participants on the plan or less participants on the plan as of the first day of the plan year, but the plan document requirement still applies even if you are exempt from having to file 5,500. So what to do if you're not currently complying with the plan document request? So obviously the best way to fix this is to get an ERISA wrap document in place ASAP. If you don't have one and need assistance, let us know and we can get one in place for you and give you the instructions on how to distribute that in the proper manner at the proper time. Also, if you don't currently have a cafeteria plan or POP document in place, then that can be this as well. Then you'll need to adopt it, which means you'll review it and you'll sign it, give it out to those plan participants. Ongoing, you'll give it to each participant after they enroll within 90 days.
So and that what they said when you said, are we going to have any in person?
Can you repeat that?
Attendees should all be on mute. I'm not sure how someone was able to unmute themselves. So please keep your mute button on. Thank you.
Okay, yes, if you have questions, please type them in the chat and then we'll be happy to get those answered for you. Okay, so again, if you don't have a plan document, a ERISA wrap document, in other words, get that in place and distribute it in the correct time frames. Okay, so moving on to the third biggest mistake that we frequently see with complying with the health and welfare benefits. A lot of times when we review the handbook, and we look also at the carrier contracts or your wrap document, your SPD, the things I just mentioned, they don't match. A lot of times they say completely different things, and this is a problem because whatever you disclose to your employees, that could come back and bite you, because sometimes they are actually vested in benefits that are communicated to them, meaning they have rights to those benefits, even if it's not something you actually provide, or worse, the carrier sees it as this is not an eligible person to receive this benefit. So what I frequently see, and let me show you an example here. The carrier's contract, meaning the insurance company's contract, that long booklet that they send you, maybe you get one from, you know, Delta Dental or Mutual of Omaha or Blue Cross Blue Shield or Anthem or United Healthcare. They send you this long document. It's the carrier's contract. The carrier's contract may state that an eligible employee is one who is regularly scheduled to work at least 30 hours or more per week upon hire, or somebody who's basically out on FMLA leave, which is generally only 12 weeks per year. Of course, there's exceptions there. But generally speaking, this is who is eligible for insurance coverage. Now, sometimes you see in disability contracts where they allow some kind of leave if the employee is on some sort of approved leave that is not FMLA leave. They will allow for it, but you have to make sure that it actually says that in the carrier's contract. And then you take a look at what is actually said in the handbook or some kind of leave policy, or sometimes even in new hire documents, just whatever you communicate to them. It may promise, for example, something like this, and this was actually taken from an actual handbook. Employees on disability leave of absence will retain their ongoing seniority and benefits. Health and life insurance will be provided for a period of 6 months. Now, when I saw this, I was pretty alarmed, because when I looked at the carrier certificates of coverage and the eligibility requirements for the carrier, I saw something like the first one where they had to be working, actively working. And if they were not on FMLA qualified leave, just some sort of employer provided leave, then this would make them ineligible, meaning they are not eligible for health and life insurance benefits under the carrier's contract. And you do see situations where someone has a big claim while they're out on leave, or even worse, they pass away while they're out on leave, and they don't actually have eligibility under the contract anymore, and that claim is denied. I have seen situations where employers have been taken to court over that, and they actually had to self-fund those claims because the carrier wasn't going to pay it. Sometimes the carrier will agree to pay it, but it takes a lot of effort to get them to do that, and a lot of back and forth, and that's if you're lucky. So really, the fix here is to ensure that these two documents match, or these documents that you're providing all say the same thing. So again, any benefits continued while not actively at work, meaning out on leave and it's longer than maybe till the end of the month, must be allowed under the eligibility provisions of the plan document and the stop loss carrier's contract if you're self-insured, including the ancillary benefits. So don't forget about those: dental, vision, disability, and life. Those are benefits that employees use and they need, especially if they've been told that they have eligibility for those. So under ERISA, the plan sponsor has that fiduciary responsibility. Remember, I talked about that in the beginning, to follow the terms of the plan document or SPD, meaning you have to follow what it says in writing. Otherwise, if someone incurs a large expensive claim or dies while out on non-FMLA leave, and the policy or SPD says this person is ineligible, the carrier again could deny it, and the employer could wind up self-insuring that claim. I have seen it. Worst case scenario, this could cost hundreds of thousands, if not millions of dollars. So in order to take care of this, this is something you can look at this week. Review your handbook, your leave policies, and other employee materials. Compare them to what your wrap document and the carrier contract state. And where there's a conflict, you need to revise your handbook or amend the plan documents, which could trigger an SMM requirement. Also, you may have to check with your carrier or your stop loss carrier, meaning your insurance company, or if you're self-insured, the stop loss carrier, for actual eligibility under the plan. to make sure that everything lines up, your leave policies especially. Make sure that those are lining up with what is allowed under the carrier's contract. So number 2, ACA Misclassified Employees. So ACA, the Affordable Care Act, we've been complying with, or we've had to deal with that for the last about 6-7 years. It came into law in 2010, but it really started to apply to employers in 2014 and 2015. So by now we really need to have this buttoned up because it doesn't appear that it's going anywhere. It wasn't repealed under the last administration, and if anything, it's going to be strengthened under the current administration. So under the ACA, full-time is defined as an employee who is employed on average at least 30 hours of service per week or 130 hours per month. That 130 hours per month was actually added later in regulations. So this is the requirement for a full-time person. It can't be 32 hours, it can't be 40 hours, and you have to be really careful on how you're defining employees that are actually probably full-time. We're going to get into that in just a second. So coverage has to be offered to a full-time employee by the first day of the month following their limited non-assessment period, but it can't be any longer than a 90-day waiting period. So really what this is saying is that you have to offer the coverage to anybody who meets that definition of full-time before the 90-day waiting period. So your waiting period can't exceed 90 days. So it would be first of the month following 60 days, following 30 days, or date of hire, just however you define your waiting period. But it can't be longer than 90 days. And this limited non-assessment period word, this actually relates to how you do your reporting, your ACA reporting. So applicable large employers, remember, applicable large employer is an employer who has 50 full-time plus full-time equivalent employees during the previous calendar year. So by now you would know, hopefully, that you are or are not an applicable large employer. If you don't know, please reach out to us and we will help you make that determination. So applicable large employers have to offer minimum value, I put it there for MV, minimum value affordable health coverage to at least 95% of their full-time employees, or they could be assessed a penalty. And some of you have probably seen a penalty letter. Whether you owed it or not, employers are getting them based on who receives a premium tax credit on the exchange. However, employees who are actually full-time are often miscalculated. In other words, you have to look closely at the defined terms under the ACA for people who are interns, people you're calling interns, temps, seasonal employees, contractors, PEO employees, and just general part-timers, because you actually could be not offering coverage to people that are defined this way, but they actually are just full-time people that you need to offer benefits to. So let's unpack these types of employees a little closer. So first of all, variable hour employees. These folks are people that you can't determine upon hire if their hours will actually be full-time. These would be folks like PRN employees, servers, bartenders, and just part-timers. Really, when you hire somebody part-time, they could technically work over full-time hours at some point. So really, we want to be tracking these folks for up to 12 months in a look-back measurement period. This look-back measurement period is permitted under the ACA for anybody that's considered variable hour, meaning, again, you have to look at it and say, I can't tell if they're going to work full-time hours or not. They may not, but if it's not a full-time position, then we need to be tracking them during a look-back measurement period, which can be for up to 12 months. It can be 6 months. There's a lot of rules around it. If you have one of these in place, then please continue to do it, but make sure that you're also including part-timers, people that you think, oh, they only work 28 hours a week. You actually want to be measuring them just in case they do bump up at some point over into the full-time category. Then at the end of the look-back measurement period, if they actually average 30 hours or more, then you would offer coverage at that point through their full stability period. Seasonal employees, these are another area where I see a lot of confusion. And it isn't just enough to say, yeah, they're seasonal, that's how we define it. You have to actually look back at the ACA definition of a seasonal employee. Under the ACA, and I put it right here for you, an employee who is hired into a position for which the customary annual enrollment or annual employment period is 6 months or less, then you can place them in a look-back measurement period. You don't have to offer them benefits as of the first of the month following your date of your waiting period, or however you define that waiting period. However, you do have to place them in a look-back measurement period. They may not work 12 months, so that's fine. But in case they do, and that often happens where you have somebody who is actually, you hired them as seasonal, but you like them, you kept them, and they continue to work. This gives you some clarity about when to offer this person benefits. But if you've got a person that's really not meeting this definition, maybe you call them seasonal, but actually they work more like 8 months out of the year, and it's kind of random. It's not really during the summer. It's not really during, you know, the holiday break. Then you have to think about, is this person actually a seasonal employee? Are they actually more like a full-time employee? And if you hire them and they're working full-time hours and they don't meet this definition, then you have to actually offer them benefits as of your waiting period. So just like any other full-time employee, even though you know that they're going to be only temporary, you have to offer them benefits if they're working full-time hours upon hire, and you know that. Just like any other full-time employee. And I think there's a lot of confusion around this, but hopefully that provides some clarity about how to treat a seasonal employee. So contractors, temps from staffing firms, PEO employees. So this gets into really who the common law employer is, the recipient employer. The person, common law employer, is a test based on the substance of the relationship between the employer and the employee, meaning who is really acting as the employer here. If that's you, then that applicable large employer, ALE, has to offer health insurance coverage or offer coverage through some sort of contractual relationship on behalf of the client employer. Meaning sometimes when you use a staffing firm, you pay an extra fee for that offer of coverage. So that's very important that you figure that out here with any contractors, temps, or PEO employees. Contractors really are different, because contractors, if they truly are contractors, meaning you are not their employer, they provide services to you, but you don't have them clock in. You don't give them a schedule. They work as needed out of their own expertise. Then in that case, you would not have to offer coverage. But if really they're acting more like an employee and you're their common law employer, then you do have to offer coverage, just like I mentioned before. Full-time, if they're full-time, offer them benefits. If they are working under 30 hours per week and you're not sure how many hours they're going to work, then they can be placed in that look-back measurement period. Temp employees. This is something I see a lot, where an employer says, we're going to hire this employee. They're only going to work here 5 months. They're not really a seasonal employer. You're not calling them that. But again, you have to look at, okay, they're not a seasonal employee, but they're only going to be temporary. And the ACA actually says that ALEs cannot consider the likelihood that employees will terminate employment. So this means that if an intern or a temp is working full-time hours, even if it's on a temporary basis, you have to offer them coverage after the full-time waiting period. Otherwise, you could be assessed an employer mandate penalty. So it's very important that you take a look at your workers and how you classify them and say, yeah, these people are actually full-time and we need to offer them benefits just like everybody else who's full-time. Then if they are actually variable hour or part-time, or actually meet the definition of seasonal, then you can place them in that look-back measurement period of up to 12 months. So review your employee classifications, determine if you should be offering coverage. Again, set up those look-back measurement periods. If you have variable hour workers, part-timers, include them as well, and avoid creating your own definitions because you don't want to offer them coverage. Instead, go by the ACA, use those look-back measurement periods to your advantage. If somebody quits way before 12 months, you never have to offer them coverage, and you've met your requirements under the Affordable Care Act, and you won't receive a penalty. You won't be assessed a penalty, in other words. So moving on to the number one issue I see, and that is COBRA. And I think a lot of people might say, COBRA, that's something we have our hands around. And I would actually say, maybe not. Maybe, yes, a lot of things are taken care of because you use a COBRA vendor or you feel like you have a pretty good handle on it. But I want to stress to you the importance of COBRA. COBRA is something that employees use when they need it. They frequently take COBRA because they have large claims, they have a health condition that they need coverage for. So you really, really have to make sure that you comply with COBRA and that you are meeting all of your notice requirements at the correct times in the correct manner. And I'm going to talk about that. And as well, I'm going to talk about the new legislation. So COBRA is the employer plan sponsor's responsibility. It is not the vendor's responsibility solely. It's fine to use a vendor. They do take some of the burden off of you. They will indemnify you at some degree, but it's really, really ultimately the employer's responsibility. And the employer is the one who is going to be named in a lawsuit or a complaint, or if there's an informal complaint made with the Department of Labor, then they're not going to call the COBRA vendor, they're going to call you. So it's really, really important that you know what the COBRA vendor is doing and that you stay on top of that. So plan participants include anybody who is a COBRA qualified beneficiary. So in other words, getting back to the plan fiduciary responsibilities, I talked about making sure that the benefits were loyal to plan participants. That includes COBRA QBs, qualified beneficiaries. COBRA is complex because it involves many triggering events, secondary events like death or divorce, numerous timelines, various notice requirements, and now onerous rules due to the COVID-19 legislation and regulations. So individuals use COBRA again because they need it. Qualified beneficiaries can make informal complaints with the Department of Labor, EBSA, Employee Benefit Security Administration. That's the department of the Department of Labor that deals with this. And COBRA group health plans includes not only major medical, but dental, vision, health FSAs, HRAs, sometimes on-site medical clinics providing medical care, some employee assistance programs providing medical care, telemedicine benefits if they're standalone apart from the health plan, ICRAs, and just any other plan providing medical care. So keep in mind that COBRA doesn't just apply to dental, medical, and vision. It has a lot of other things that could apply as well. So let's talk about the big notice here. So COBRA has many notification requirements, and one of those that often gets overlooked or done incorrectly is called the COBRA initial notice. It's not the election notice when they actually trigger COBRA, they quit, they have a reduction in hours, and they elect COBRA. No, this is the COBRA initial notice that I'm talking about. This notice has to be provided to them when they first enroll in the benefits. So it has to be mailed to new participants within 90 days of the coverage effective date. So it's not enough to give it to them via email or a paper copy. Instead, really the best way to get it to them is through mail, first class mail. You don't have to have a confirmation sent back to you, but that first class mailing serves as proof of receipt if you're mailing it to the address they've given you. And remember that COBRA allows spouses to have separate COBRA rights. So you have to mail that to the individual and the spouse. So it can be two different COBRA notices, initial notices here, or you can address it to Mr. and Mrs. So-and-so and spouse, or Mr. So-and-so and spouse, or Mrs. So-and-so and spouse. Emailing or handing it to employees is not sufficient because, again, of that spouse requirement. You can't know if the spouse received it. And this comes up when there's a divorce, because oftentimes there's a divorce, that spouse has separate COBRA rights, they weren't notified properly of their initial COBRA notice rights, and then you don't have a defense if there's some sort of claim that comes up. Otherwise, and if there is that notification of a divorce, and you haven't sent this out properly, you can't impose that 60-day deadline for the divorce notification. So really important to make sure that you are complying with the initial notice, meaning that your COBRA vendor, or if you self-administer COBRA, you're mailing it out via first class mail within 90 days of enrollment in one of the medical plans. So let's say they enrolled in just dental and vision. You need to mail a COBRA initial notice at that point within that 90-day period. So take steps to ensure that your COBRA vendors are notified when somebody first enrolls, not when they quit, but when they first enroll, and that they are able to mail them out, or if you are going to be doing that, make sure that you have a way to do that. So I want to talk briefly about the COBRA outbreak period guidance. So if you didn't know this already, there was guidance that was released last year that has subsequently been sort of renewed or clarified because it's been 1 year since the original guidance was effective. So we went, the national emergency period was declared as of March 1st, 2020 because of COVID. That day came and it went, and we have DOL guidance related to timeframes that have to be suspended for COBRA timelines, in other words. So these timeframes have to be suspended for the earlier of 1 year or 60 days after the president declares the national emergency period is over, which hasn't happened yet. So that applies to the 60-day election period to elect COBRA continuation payments, to elect COBRA continuation. So just to tell you, yes, I want to continue on COBRA. That 60-day normal election period has essentially been suspended. So in other words, what this means is that they could have a full year to elect COBRA. Now they would have to come current, most likely, on their COBRA premiums, but they have that extra time to elect COBRA. Usually we have these kind of stop gaps in place to prevent people from taking COBRA after too much time has passed. But under these rules, essentially they have up to a year. The date for making initial or ongoing premium payments has been suspended. So normally you give them a 30-day grace period to pay COBRA. They actually have a really long grace period now, up to a year, or before, if it's sooner, the national emergency period is declared over. Also, the date for individuals to notify the plan of any qualifying event or determination of disability, so divorce, legal separation, child aging off the plan, those timelines normally in place to notify you, suspended for a year. Also, COBRA subsidies under the most recent piece of legislation that was just passed last week. COBRA participants, what this says is COBRA participants must be provided a subsidy, 100% subsidy under this ARPA legislation if they meet the following criteria. So in other words, their coverage has to be paid, their COBRA coverage, if they so elect it, has to be paid for a period of 6 months or up to 6 months from April 1st to September 30th of this year, so 6 months coming up very soon, if they meet the following criteria. So coverage would have had to be lost due to involuntary termination of employment or reduction in hours. The COBRA participant still is within their COBRA eligibility period. Eligible COBRA participants who did not have an election in place will have an opportunity to make an election during this extended period. This will be referred to as the look-back period. Eligible COBRA participants who have an election in place as of April 1st will be able to take advantage of the subsidy effective April 1st. And eligible COBRA participants who were eligible on or after April 1st of this year will be eligible for that subsidy for the remainder of the subsidized time, so that's 6 months. So this means that the employer, you, have to pay their COBRA premiums if they meet this criteria for up to 6 months. Now, this would only apply if they lost their employment due to involuntary termination or a reduction in hours. So meaning they were laid off, they were fired, not for gross misconduct, but if they just quit or resigned, this wouldn't apply, but involuntary termination. So it's very, very important that you understand this piece of legislation. I don't have time to go into all of it today, but very important to get with your COBRA vendors on how this is going to be administered. It's going to be paid back to the employer via a tax credit through the federal government, but the employer does have to pay it first. So what to do if you're not compliant with COBRA? You want to provide notices to your COBRA qualified beneficiaries at the correct times upon enrollment, election periods, during their premium and grace period for payment. Also with this that I just mentioned, outbreak period notices, COBRA subsidy notices, and notifications of changes to COBRA eligibility. Consider using a COBRA vendor if you are not currently, or if they seem to not really be on top of things, maybe it's time to look at changing COBRA vendors. Contact them, get with your representative, and make sure that you understand what they are going to do and what you have to do. And create an internal COBRA procedure so that no one falls through the cracks. You're monitoring who's terminating, you're monitoring how they're terminated, you're monitoring if they had a reduction in hours, you're monitoring divorces or deaths or somebody aging off the plan. There's got to be some kind of internal process for you to make sure that you're not missing somebody so that you can tell the COBRA vendor who has triggered COBRA. So I have a couple of bonuses here. You will get these slides. There's a lot of questions about health plan notices. So I just put in a table here about which notice is required when, and if you can put it in the open enrollment materials. I don't want to take too much time discussing this today, but I provided a table for you about what notices not to include and what notices to include in your open enrollment materials as well as your new hire packets. This is also something I see that is kind of confusing and could use a little bit of work. Okay, so I want to take this last poll question. I'm basically asking the same question that I asked before we got started. So how confident are you feeling now about your company's health plan obligations after the information discussed today? Do you feel still, yeah, we're pretty confident overall? A, we're still on top of it. B, we've got some work to do, but it's manageable. C, I'm feeling very nervous and I need some help. D, I am still totally lost. We are doing almost none of these things. So go ahead and mark. These are anonymous, so please make sure that you answer truthfully so we can get a pulse of how everyone is feeling after this information. I know it's a lot. Okay, so it changed quite a bit from the first part, which I thought maybe that would be the case. Luckily, I see no one in the last column where you're still totally lost. That's good. But most people are hovering around. We've got some work to do, but it's manageable. Some of you are feeling like you're still pretty confident. Awesome. A few folks are feeling pretty nervous and may need some help. Understandable. So with that said, we have resources for you. BSG Hausman Johnson Insurance has many resources to assist you with your obligations. If you are feeling that you need some additional help, please contact your representative for assistance. Also, make sure that you're speaking with your COBRA administrators today to feel fully prepared to assist with these recent changes, as well as just the ongoing everyday changes under COBRA. Hopefully in about 6 months, COBRA will go back to normal, but that remains to be seen. Also, if you're interested, you can take a free online self-assessment to get your compliance score and report. This link here will be included with the slides. I don't think you can click on it here, but make sure to take that assessment. The results will come to us and we'll email them to you, but it's totally free and it just gives you kind of an idea of whether or not you're feeling like you're meeting your responsibilities. So with that, we have time for some Q&A. We have about 8 minutes. And here are the numbers for SHRM and HR credit as well. Are there any questions?
As we mentioned, you can type into the chat feature to ask a question for Sarah. So our first question that's come in is, we terminated an employee in February because she had exhausted her FMLA and wasn't able to return to work. Is she eligible for the fully paid COBRA through September?
So she was terminated. Okay, so she didn't come back to work. She was under FMLA, didn't return to work, and you offered COBRA. So in this case, likely not, because you have to be terminated involuntarily in order to be eligible for the COBRA subsidy. Now there is also a requirement or eligibility if you had a reduction in hours, and that can be for any reason. So You need to take a look and see, did this person actually just terminate employment or did they have a reduction in hours? But most likely with an FMLA leave that's exhausted or they didn't come back to work, there would be a voluntary termination of employment and likely the subsidy wouldn't apply. So good question.
Great answer. All right, anyone else with any questions? Going once, going twice. All right, well, if you think of anything after the webinar, you are welcome to reach out to us and we can send your information over to Sarah and she can answer any questions you may have. We want to thank everybody for attending today. Thanks so much for taking some time out of your day to learn about compliance. We'd love if you filled out the short survey for your feedback. It's incredibly important to us. We love to see how we did and what you're interested in learning more about. And we hope you can join us for our next webinar in April. It's going to be on builder's risk. It's sure to be a fun one. So with that being said, have a great rest of your morning and have a great day.